money, banking, and trust by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Tuesday, September 21st, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. I understand that we're probably having some difficulties here on free conferencing getting in. Apparently they're experiencing some difficulties, so you might have to call some of your friends and tell them to keep on trying to get in. Eventually we'll get in. So let's go to Q&A and see what we can do there. So we're in Q&A, so raise your hand, press star 6 followed by a 1 to raise your hand and get in the queue line. Star 6 followed by a 1 to get in the queue line and raise your hand. Star 6 followed by 1. Anybody? Question? Star 6 followed by a 1. Star 6 followed by 1 to get in the queue line. Raise your hand. State your name, where you're from. Right. I was doing some research on looking through Black's Law and various other places, going over a pleading for a credit card, and I ran across a credit card document that was talking about limitations issues. And basically limitations, if you look in Black's Law, is really privileges. And this was an application to Texas, though. But this says that the statute of limitations for breach of contract is 4 years. And most credit card contracts provide that failure to make a minimum payment when it is due as a default. And it goes on the next paragraph, says, even if contract choice of a law provision selecting the law of another state, Texas will apply its own statute of limitations, notwithstanding the choice of law provision, because, here it is, limitation statutes are procedural and not substantive. And when I read that, I said, boy, that's a bingo there. Limitation statutes are procedural and not substantive. And we've talked on some of the past shows about privileges, which are really nothing more than what the statutes and codes grants you, which are the rights for actions in a statutory at-law court. So they say they're rights, but they're not really rights. They're rights of actions granted by statutes, which is nothing more than a privilege. And these privileges are limitations on your rights, and you don't know that. So all statutes and codes are limitations on your rights. Now, the limitations of the statutes and the codes, or the privileges, they're procedural. And the at-law public side of the court is all about form, process, and procedure. All procedural and not substantive, because substantive, to be truly substantive, it would have to be in equity, where your substantive rights are the real man. So all this stuff, you find this, you dig around and you find this stuff is scattered here and there, little golden nuggets of, it just really tends to bring it together. But the privileges are limitations derived by statutes and codes. And privileges are procedural and not substantive. And procedural privileges can be nullified by equity. But today, no one enters into a court of equity, just a court of at law. So if we learn how to invoke a court of equity through NTT and trust use to overcome the statutes and codes privileges, then we'll have the enforcement of our. So we're going to bypass the procedure, which is the limitations granted to you by the privileges of the statutes and codes, because all those statutes and codes are for the fictions, not for the real live man. And we keep living in a democracy as real live people, and we need to live in a republic where our substantive rights are, and learn how to control both sides, utilizing our straw man, as well as operating on the private side. So we're in Q&A mode, so press star 6 followed by 1 to get in the queue line for asking questions. Press star 6 followed by 1. Raise your hand, get in the queue line, state your name, where you're from. Star 6 followed by a 1. Anybody got a Daniel? You're unmuted.
Hey, Christian. Good evening. How you doing?
How you doing?
Not so bad. Doing all right out here.
Yeah, did you have trouble getting in?
No, not at all. Got right
No?
through.
Okay.
I noticed there's an issue on the Ford Shared site. I noticed some problems with that earlier this evening, but I'm sure that'll get cleared up.
I guess they're working on it.
Yeah. I had a question relating to, I was going back to some of the old calls, and I came across that one, I can't remember the guy's name, but Carlos got on too. They were talking about the land trust, or forming some sort of a master trust where you take your fixture schedule or whatever sweat equity that you can demonstrate and place that into some sort of a trust and encumber it with some kind of a security agreement. Is that something you would endorse at this point in time?
I would endorse anything that throws a monkey wrench in the public side system to foreclose and take your property.
Right. Well, that's
yeah, but you got to realize that it's just fixed. Even on the at-law public side, that's not really achieving the goal. And you must come back onto the private side and do NTT process.
Well, that was my next question. I was thinking of doing like a dual process, pulling our notes out of general deposit, replacing them in a special deposit, with the bank or whatever, and doing the whole, NTT process on the note and extinguishing the debt, and then at the same time put your put whatever equity you've put in the house throughout the time that you've been there in another trust and encumber that or lien it or whatever it is that we could do to put a stick in the spokes and put a halt to this thing. So I was thinking if we could do dual trust processes, because it'd be two separate trusts dealing with two separate trust res property.
Yeah,
on one.
It runs a dual process on the public side as well as the private side. Because
right.
That philosophy is you have to control both sides. But you just want to get enough on the public side to get you into the case so that you can invoke the equity side of the courts.
Well, so you
really don't want to traverse in on the case, which is really creating an argument and start arguing the facts. You don't want to.
Then you're back at law, right, at that point.
Yeah.
Now, to do it colorably, on the one trust, on the, I believe the land trust thing is you form a master trust and you name someone that you know as trustee, and they're all separate parties, and then I would grant my interest via a grant deed, and this is California, so it's a deed of trust state, and file a certificate of trust, which I believe is what California Recording Office recognizes, and basically just convey all my interests in the attachments in the property, like whatever improvements I've made or anything like that. And so colorably, that would just be notices in the public that the California recorders recognize, right?
Yeah, just some kind of colorable notice that's reflecting to the real facts held in private. So I like have some kind of SOI, but that SOI would be a colorable SOI that would make it look like I've got something there, so that my NOI wouldn't time out. But it's pointing to the in-chamber facts, and that's how I'm going to get into in-chambers. When they say, well, that's what we need an evidentiary hearing for in chambers.
Well, that's assuming that after we've done our notices, we bring an equity bill, a pleading, right? An equity.
Yeah. Mm-hmm.
Okay, which is what we were working on last night.
Yeah, right. So we're just, where's that separation point where you just put in enough colorable SOIs that you don't really reveal the facts that gives away your privateness of what you've got. So you can mention that you have a trust, but you're not mentioning whether or not you have a private trust. And you can put in your secondary facts, which would be indicating that the indenture was sent and you had the intent, purpose, party, specific res. And the next fact would be by itself that the method of delivery. And that's kind of like what we were going over last night.
Right. And the stating part, and I guess the stating part was the where you make your claim, spell out the details and circumstances of the trust.
Yes. Uh-huh.
Right. Also, I was digging around as far as what California accepts, and it looks like that certificate of trust. They use that in lieu of the actual trust instrument. So is that virtually the same thing as a UCC1 as far as a colorable public notice?
Okay, I'm not quite following you. What now? The UCC1?
Yeah, well, a UCC1 is just an informational filing, just saying that a trust exists. It's the NOI, right?
SOI.
Oh, I'm sorry, the SOI. So now, here in California, there's a recordable document that they recognize out here called a certificate of trust, which
that's too much information, I think.
Yeah, it wants to know what the name of the trust is, who the grantor is, who the trustees are, and it actually the document.
That's purely statutory. I really don't want to do that.
Right. Yeah, I was reading over that form, and I'm like, well, why do they want all this information? So I was just thinking, probably don't want to go that route.
Yeah, that's going to cross it back over on the private side and give your public side. It's going to give you your trust by commingling your private information and putting it all in the public there. So I wouldn't use that.
Right. They kind of corner you with that form because in order to file it, that they want the signature. Yet, we're trying to, impose a duty on the trustee. And the trustee is, could be 3,000 miles away from here.
Yes. Now I think Carlos has got a workaround on that. What he does is he just does a certification of trust, and that way he has information in there.
Okay. Because I was trying to find the template for that, what the way the form's laid out, and I found it, and I was looking at this thing going, they want way too much information. So I had the same thought you had. So all right, well I just want to run that past you, see if to really put the.
Here's what most people don't understand. This is kind of a good point. You kind of brought that up, but most people think that under the statutes of frauds that according to real estate transactions, if there's something involved with a real estate transaction, you must have it in writing. And everybody thinks that the writing that's needed is a recording in the county. That's not so. Because if you look at what it says, actually in the law, it says that it can be proved by other writings. And what are those other writings? Could be memorabilia. I forget exactly how it states it, but it can be other letters. Like you could write a letter to your aunt or and tell them that you intended to form a trust, say, with this real estate with your grandmother. And that is the in-writing evidence that supports, say, the oral formation of a trust involving real estate. So it can be other writings because it does not necessarily have to be a statutory document recorded into the county recorder specifying. Therefore, it can be writing.
Well, then the after that is to get the county to record it. That's the other issue.
Yeah, well, I guess there's some difficulties in California about that, or somehow they changed the laws or something. But they apparently reporting notices and affidavits. That's really strange. But
I don't see why I couldn't create my own trust indenture and basically hand it to the clerk and make them trustee and liable for their refusal to do their fiduciary duty.
Maybe we're asking the wrong thing there. Maybe we should be asking, instead of recording, maybe we should be asking them to file these under the miscellaneous file.
Yeah, there's an idea. But or just get them into a trust, walk in there, deliver it.
Well, but that may cause me some problems because now I may have to enforce this thing to get it recorded. But anyway. But then there's other methods. If you're really having trouble in there on a county recorder, go to some other way. All we're doing is creating a notice, a public notice, and that's all we want to do. A public notice is outside the hearsay evidence rules that bypasses that.
So a newspaper ad would do the same thing.
There are other methods that you can achieve the same thing. It's not necessarily you have to do a UCC, non-UCC filing or a county recorder. If you got problems there, maybe pick another method. It might be a little more expensive, but it's still effective.
Right. Well, how about recording in another county or another state that will record?
Yes. Mm-hmm.
Okay. All right. Well, pretty much all I had. I'm enjoying the lesson.
So how'd you think? What'd you think about last night's?
Oh, it was great. I thought it was fantastic because I had already read that the day before, so it was fresh in my mind. And then as they're getting a repeat performance of it, but then this time it's being disseminated in a more practical way, and plus the language in that thing is so archaic, it's almost Martian, and it's just good to hear it, in a more modern sense.
Okay, thank you.
It's not a whole lot different than a normal at-law pleading for the most part, right? I mean, you're stating the circumstances and you're alleging each fact one sentence at a time. You don't want to convolute the thing. You just want to keep it simple and to the point, just like any other pleading.
Right.
Well, that's I enjoy that. I'm looking forward to piecing that thing together even further. So is that next Monday going to continue putting that bill together?
On Monday nights, yes.
Okay, great. Well, thanks a lot.
I guess we had a little problem. We downloaded the wrong book. It was the 1866 version, and some people had the wrong version. So they had an earlier version. It didn't make sense. Didn't comport to what we were doing, but.
Oh, okay. I think I got the right one.
Yeah, so 1866 is the right one. And if you don't have that, contact Faith to Trust again, and we'll give you the right link. So
when I was reading that, when the language is pretty, it's actually funny. I was kind of chuckling reading the thing. I was just imagining a judge getting this thing. If you copied some of the language verbatim, with some of that old language, I thought it'd be pretty funny what a judge would think to read that.
Yeah. We'll have to upgrade the language a little bit. Don't use exactly right out of the book what they're using.
Right. Well, good deal. Thanks a lot.
Okay, Dan. Thanks. Anybody else? Press *6 followed by 1 to raise your hand, get in the queue line. Karen, you're on.
Hey, Christian. How are you?
Okay.
Good. Thanks for that case. I've read this before. I glimpsed over it, and I still haven't had a chance to really digest it. But it was on the U.S. It was on that CIA case about the constructive trust and the breach of trust that they got him at, even though that was on the at-law side because it was a statutory trust.
Yeah, I haven't read the full case, but I read the ends on it there.
Yeah, I saw parts of it. It was interesting, and like I said, I just glimpsed over it. I didn't know if you digested the full case and if you wanted to make any comments on it, because it's generally in the same premise where they did not want him to disclose specific covert operations or intelligence, where he could express it generally, but he had to basically bring the CIA the book before he published it, and he went ahead and published it, so they got him on breach of trust.
Yeah, but here was the big thing on that case. It was actually he signed a employment contract to get employed by the CIA when he went in, and when he left, he signed another contract specifying that he wouldn't do any book publication without their consent. So they had two signed contracts, and had him in a breach of those contracts. The big thing was about that case is they did not come at him for breach of contract. They came at him for breach of trust.
Right. But it was still on the statutory side, though.
Probably, yeah.
Probably because of the agency being a fictitious entity. So it had to stay statutory, I would think.
Yeah, probably so, yep.
Okay. No, that was my only question. Last night was good. It got the wheels turning a little bit. Still working on some things myself. And once again, I thank Jeff for putting in his comments, because a lot of times before I submit anything is that I want to be sure everything is done right, so this way it doesn't have to be amended again. And there were some questions that I asked him was in regards to almost like a protocol that we have to go down in submitting, the UCC ones, the indenture to the trustee. Now, should we also contain a list, almost like at a bullet point, of the trust res, even with the indenture, even though the wording's already included in the indenture of what they are to do?
Make a separate sheet that would be a listing of what specifically is res, and then you could reference that in your indenture.
Okay.
All in and pull it all in one thing.
Yeah, so basically, just kind of so everybody understands, and it also helps me to understand, is that, of course, we have our copies of our UCC 1s and 3s, and then if there's an ongoing case, we have the copies of the court or the county notices. Now, that goes into the specific case itself, but not claiming a notice in equity or an equity notice or anything like that. We just want it to be very...
Yeah, it's just a colorable attachment to give the courts some kind of prima facie evidence that's an attachment that actually supports your case, your claim, your NOI.
Now, some of these people that are going through foreclosures, do they also include copies of the mortgage instrument, the promissory note, a current appraisal of the property to send it to the trustee also?
As trust res?
Yes.
Yeah, everything that's in that mortgage foreclosure or the mortgage closing.
Okay, in other words, as much information as you have, but what if somebody doesn't have all the original documents?
Listed anyway.
Right, listed, so that's at least on the indenture, even if you don't have a copy of it.
Yeah, yes, everything you signed your signature to.
Right, because that's what you're going to claim to receive back, because everything that was...
documents that you know of.
Right, okay, because everything was generated from that sign, that's something with the value, is from your signature.
Right.
Okay. It's day. It's just, of course, there's to understand. But I am excited, especially now we're getting into the pleading part to really understand how these are formatted. Now, are there currently like equity attorneys out there, or basically are they all at law?
Well, if they're called equity attorneys, they're probably on the statutory side, which is not real equity. I don't think you will ever see a real attorney in real equity.
At least not from this country, anyway.
Yeah, right.
Like from either England or Australia.
America, with real man, because fictions, which are attorneys, can't show up. They can't bring their bar card with them. Right.
Okay, but no, it's getting better. It's just a lot of digesting of it's like a new formation is what it is, but it's great. It really is. It's just actually setting the time aside to really learn it and study it and being able to talk the talk and walk the walk. That's the big key more than anything else. I mean, you better know how to prove it once you get into court more than anything else.
Right. You got to be able to get it in a court of equity, so you got to be able to claim and prove the trust.
Right. Now, but the thing is, even prior to getting there, we got to be sure that particular court, whatever court we're going into, is a court of equity.
Yes. You got to get into a court of equity, which means check first, see if it does have a court of equity available to you. If not, remand it to some other court so you can get into equity.
Now, you should be able to, if you're coming in, let's say if there has been a foreclosure action and they've already foreclosed on the property, but now we're coming back in, and we don't, technically, if someone is not in that same area and they've relocated to another area, really their counterclaim could be anywhere. They wouldn't have to really file for a change of venue, would they, since it's actually a new action?
If it's a new action, they probably wouldn't, because that would incorporate it into the new action.
Right.
If you got a case in that and you find out that there's no equity in that court.
Right.
And start a new case someplace else, and then pull that one up into it, or remand it to that venue. Right.
Exactly. Right. Okay, that's...
Got to get into a court of equity. So check first to see if that court has availability of equity. And it's probably a little bit different from state to state, but I'm looking at it probably that municipalities or cities do not have courts of equity. Usually the county does, the state does, the circuit courts do, and the federal does.
Mm-hmm. See, I thought about that even like in when I lived in in Sarasota. But the court system was the 12th Judicial Circuit, but it was located right downtown in the municipality. So the question is, was it a municipal court or was it the county court?
Well, I think the county and the state are kind of like thrown together, especially in Florida here. So
yeah, it seems like it.
Yeah.
Okay, no, that was my only question at this time, Christian. Thanks a lot. I appreciate it.
Okay. So we've been bringing up, talking about indentures, and I gave a small indenture last night, and I kind of revised that. So here's the new one that I wrote. Grantor in equity, granted in confidence, in reliance on in the past, for the trustee to have the use of his equitable signature to be returned in kind sometime in the future, along with all proceeds therefrom at the grantor or beneficiary's order, period. Grantor in equity, granted to the beneficiary to hold the right to take a fee and or performance/duty as merging and extinguishment, discharging obligations or debts for beneficiary's education, support, and maintenance for life, with the remainder to his heir or heirs. Beneficiary has the right to determine the quality and quantity of his education, support, and maintenance for life, period. The trustee has all power to do all lawful acts requisite for effecting the premise, period. So there's a trust indenture example. So anybody wants to ask a question, press star 6, followed by 1 to get in a queue line. Press star 6, followed by 1 to get in a queue line. Okay, Pierre, you're unmuted. Hello, Pierre, you're unmuted. Hello? Yes, we can hear you. Hello, Pierre, you're on the air. Hello? Yes, can you hear us all right?
All right, can you hear me?
Yes, can hear you now.
All right, thank you. You said something at the very beginning of the call tonight, and I forget what it was. We got off talked about a few subjects, and I apologize for not remembering what it was I want to talk to you about, but there is one thing I want to pass by you here. This may be on the debtor-creditor side. It may be also be on the equity side. Through my studying of your work, Christian, and of Mary Croft and Greg Gentry and all that stuff, I want to pass by you an idea that may help a lot of people. And is it in equity? I'm not really sure, but I want to pass this idea by you anyhow. When we go to a store, we'll use Walmart in this case, for example, and we buy a pair of jeans. We walk out. We can't just walk out because we have to go to the cashier, and they ring it through, and they give us a bill and a receipt, and we give them Federal Reserve notes, or also known as money in cash, to get that. My thing is this. I've always wondered, why is it that if you were to make, say, for ease of sake on the conversation here, you were to make $100,000 a year, you actually had $60,000 in receipts for the year in expenses, but yet you can't declare that on your taxes. Now, this is where it comes in fine line. Is this equity or debtor-creditor? And I apologize if it's on the debtor-creditor side, Christian, but just hear me out for a second, please. I passed this by Jack Smith last week, and he thought it was pretty interesting. He's going to think about it, and I don't know if he talked about it on his class last night or not. I haven't listened to the call yet. But my thought is this. If we're to stay in honor and operate in commerce, whether it be the private side or the public side, I say this. When you sign the application to go work for somebody, and again, let's say you go to work for Walmart, they give you a bill. I believe this. I think we, the living man and woman, should be giving the employer a bill and a receipt when they give you a check. Does that make sense to you?
Yeah.
Because also now you sit there, and like I said, it's a fine line here because Paul Capel told me on a call. He said, Scott, when you work 3 hours, whatever it is, a week, you just gave 40 hours of your life away you can never ever get back again. And I remember that, and through your calls, Christian, and like I said, and Mary Croft and Greg Gentry, and putting all this stuff together, I'm going, what's missing on the puzzle here? We don't have anything to claim our sweat equity with. We just get a piece of paper, and at the end of the year we get a W-2 or W-4, whatever it is, for taxes. And we have nothing to claim our sweat equity. And that's where I'm saying, is this on the debtor-creditor side, or is this on the equity side?
And we're making it on the debtor-creditor side ourselves. But what we're doing is we're expressing the debtor-creditor, and instead we should be expressing the trust side. Right.
I agree with you on that one, Christian. I'm just going from the point, though, I think that I haven't figured it out yet how we would do it on the equity side, but I still say we got to have a darn good shot at doing it and giving the employer a bill and a receipt. And it would have to, and if I'm correct, it would have to be done through a trust that you set up for yourself, and then through that trust, the trust would then issue the the employer, your employer, the bill and receipt, and therefore you could there declare all that as a 100% tax deduction.
Yeah, we could utilize the trust that's already been set up, so
right.
We could utilize that.
Okay. The call last night was pretty good. I enjoyed listening to it like that. The one gentleman, he was in control of the conversation, which was great. I do see room for improvement. I do see that over time, those guys, the 4 or 5 guys who were talking last night, will come along a long ways as long as they keep at talking about the subject and talking it out as they were last night, which was very good to hear that part as well. So I was very pleased to hear that. Again, at the very beginning of the call here, you were talking about something, Christian, and I forget what it was, so I apologize. But I didn't want to pass a thing by you like this. I think that if everybody out there that operates in commerce was to somehow get a trust set up, or even somehow just issue their employer a bill and a receipt for their sweat equity, things would turn around a little bit. I know people may look at getting fired, but I mean, at what point do you not stand up for yourself and say, hey, this is my labor, and I got to be accountable for this to where it's going? So, by the way, I just want to let you guys know, for the one gentleman the guy sitting there said about the second caller tonight. I was reading online tonight where there's the Vatican, actually in 1976 was declared sovereign. The Vatican over in Italy, or wherever it is over there, is actually in 1976 was declared sovereign, and the Italian police just seized $32 million from the Vatican Bank. I'd be pretty interested to see what's going to happen with that one. So that's all I had to say. Thank you very much. I appreciate it.
Okay. Yeah, you mentioned that we're operating in commerce. Well, we're under NTT. We're trying not to operate in commerce, and we're going to operate solely in equity through a trust. I agree with you, Christian. I agree with you 100% like that. It's just that right now there are so many people out there that are trying to get out of commerce and into equity. And I'm trying to give it, like I said, it's a fine line because it's our sweat equity that we give. So I mean, that's on the private side, which is equitable, right? And like I said, right now, and there's just, I'm trying to give it was just listen to your calls, Christian, and listen to Mary Croft and Greg Gentry. I started thinking about the bills, the charge, the bills. And I said, why are we not giving our employer a bill and a receipt when they give us a check? This is like you go into Walmart, you pick up a pair of pants, you walk out. You can't just walk out because they have to give you a bill. You got to give them a check, and they got to give you a bill and receipt. So the same thing. You go to work for your. Well, it's really the order that I'm going to give them to merge the titles because they're repudiating the duty as trustee and trying to shove it back on me when they send me the bill. Right, and like I said, I didn't want to get the whole long spiel with that because I didn't want to cross the line over the debtor-creditor law because I know you're trying to stay on equity, but it's just an idea I have, and there's an awful lot of people there who are trying to resolve their problems like that, so I thought I might mention tonight on the call. Like I said, I'm usually pretty quiet, but it's pretty darn good. I like it, though. Thank you.
Hey, Carlos?
Yes, sure.
Hello.
Hi, Carlos.
Hi, Can you hear me?
Yes, can hear you.
Okay,
fine.
Great, because I was hearing some kind of echo. Do you know if the Carpenter versus Langen, 1872, was it repealed? Do you know?
No, I don't know.
Do you remember that case?
Vaguely.
That's a real good case in equity and a foreclosure. It's a real good case. Yeah, we should go back and review that one. I just thought I'd bring it up. Have you read it? What's in it specifically? Yes, I have read it. I put it on my computer. My computer reads. I don't have to read it. It actually reads it for me, because I'm kind of nearsighted, so I have to get some other kind of help. And I bought a new computer which reads all the books for me. I just lay down and concentrate. And I just went through this, and this guy for $980 back then got a loan. They were foreclosing on that person, and then they didn't bring no codes or statutes. Everything that they brought in there was according to equity. Yeah, I just read it. I just heard it for about 2 or 3 times. I need to memorize it because that's what I'm gonna base my pleadings on. I think it's something to concentrate or something to look into it. It's great. What was the year of the case? 1872. Carpenter versus Langen. 1872. It's about a foreclosure deed of trust. The bottom line is that they finalized and said that whenever the deed of trust splits from the note, it's null and void. actually what we need. And it's an old case, and some guys say that it's been repealed, and I spoke to someone who's very active in this. No, he says it hasn't been repealed, and this guy is on top of foreclosure. He's a real good guy. His name is John Stewart, and he says no, it hasn't been repealed, and just go by that. And I went to that pleading. I went to that case. It's all about equity, 100%. So
it involved trust also?
No, it did not involve anything in trust. It just brought in all the maxims of equity and equity. That's how we can start a law. We could bring in this case or the properties of this case, and then put them into our pleadings in equity, fight back, and then we can progress in and take whatever route we want to take, as in like merging titles or anything. We can open up the case with this. That's what I'm trying to say.
My question was, if there was no trust involved, how did the titles get split?
Well,
get bifurcated.
Yes, well, it was bifurcated because they separated the deed of trust from the note. It's never been together. So therefore,
I would think it would have to be by a trust mechanism, because that's the same thing what happens in securitization.
Right. And it's the same identical thing. The only thing that they did not tell you, or they did not tell me when I went to sign for my mortgage, look, you're in a trust, you're the grantor, we're going to go ahead and do this. And they just did whatever they had to do to go on their merry way and actually breach the trust. We didn't know what it's more.
This call was cut short due to technical difficulties with free conferencing.